Good evening and welcome to our Women in Wills webinar featuring our guest speaker, Rebecca Morton Crable from the class of 2009. My name is Maria Howell and I am a proud member of the class of 1991 and a parent of a recent 2025 graduate. I have the privilege of leading Davidson's women's philanthropy effort called Women Act. It's my pleasure to co-host this evening's event with my colleague, Jamie Stamey. She's the Director of Gift Planning. The Office of Gift Planning is a valuable resource for everyone on this call, and we will be sure to share additional information in our event follow-up. Women Act is an initiative that brings Davidson women together to create a lasting shared impact on our students' experience. ACT stands for Aspire, Create, and Transform, reflecting our mission to build new opportunities and transform student experiences. Over the past 2 years, more than 550 alumni have supported the Wildcat Women Fund, and in total, women have given an extraordinary $40 million in leadership gifts to the college. We really hope that momentum will continue to grow. When we launched Women Act, educational opportunities were a clear priority, and that's why we are especially excited to host tonight's event in honor of National Estate Planning Awareness Week. This webinar is a chance for us to learn how to make informed decisions about our estates and the legacies we wish to leave, whether that means supporting our families or charitable organizations that are close to our hearts. We are thrilled by your response and we look forward to offering more programming. Before we dive in, I'm going to do just a few housekeeping items. First, we are recording tonight's webinar so we can share it with those who are unable to attend. And additionally, we'll send Rebecca's presentation, a planning sheet to you after the event, along with the recording. So there's no need to take photos of your screen. You can just sit back and listen. We'll have time for Q&A towards the end of this program. I'm sure that you are Davidson folks and you will have lots of questions. So as the questions arise during her presentation, please submit them in the Q&A box that you'll see right at the bottom of your screen. Nobody can see them in there except for us. They won't bother us. Go ahead and populate that during the presentation whenever you think of one. We'll get to as many questions as we can. Now to introduce our speaker. Rebecca Morton Crable is an attorney at Barclay Damon LLP in Buffalo, New York. She focuses her practice on sophisticated trusts and estates matters, including planning, administration, and tax strategies. Her path to her expertise is unique. A 2009 graduate of Davidson College, Rebecca was a political science major, an honor council member, and a Davidson Outdoors trip leader. After college, she spent 2 years working in Boston, 1 year at a public charter middle school, and 1 year as a full-time nanny while she was applying to law school. She graduated in 2014 from Washington University School of Law in St. Louis and began practicing law as a trusts and estate attorney at a law firm in Boston. In 2016, she relocated to a law firm in West Virginia and spent 8 years as a trusts and estates lawyer in Morganton, West Virginia. While practicing full-time in West Virginia, she also completed an LLM in tax law from Boston University through their online program. Last year, she relocated to Buffalo, New York with her husband, who's a political science faculty member at the University of Buffalo, and their 2 sons. Please join me in giving a warm welcome to Rebecca. Thanks, Rebecca, for joining us.
Thank you so much, Maria, for that introduction. And I appreciate all of you spending your evening with us this evening. I know everybody has a busy schedule, and so I greatly appreciate you being here, and I hope that you get something out of it. My main goals for this evening are to give you a general baseline about estate planning, give you the basics, some information about terms and words that'll be helpful if you do pursue this with an attorney, and just to help get you organized so you can plan best and make the most out of your experience with an estate planning attorney. So we'll cover 4 main topics here: the why, what, when, and how. So first we'll look at why you should have an estate plan. Then we'll turn to what's involved. What documents are we generally talking about? We'll look at when it's important to get something in place and how often do you update these documents. And then we'll talk about how you actually go about making these decisions, talking to an attorney and getting what you want in place. The goal here is not to give specific legal advice. This wouldn't be a presentation by an attorney if I didn't have some disclaimer in there. So I'm not intending to give any specific legal advice to your situation. Yeah, I'm sure we're located across the country as Davidson's network reaches far and wide. So a lot of estate planning can be state specific, but I just want to give an introduction to general principles and things to keep in mind that are across the board ideas that will help you in your planning. So the first question, why should you do estate planning? I want to talk through some common misconceptions as well as roadblocks that prevent people from getting this done. I think the biggest misconception is that estate planning, creating a will or a trust, is just for rich people. It's just not true. We'll talk about what the alternatives are if you don't have one. And then also common roadblocks. What prevents people from putting this in place or bringing it to the finish line or taking a look at what you've done before and updating it? The most common roadblocks are completely understandable. It's an intimidating process. People don't know, there's a lot of legal jargon involved. And so even for smart people, it can be confusing and intimidating. We also don't love thinking about death. We don't like planning for worst case scenarios. I have to come at this job with a little bit of a sense of humor because I deal with it every day, but most people aren't used to that. So it can often be hard to think about those what ifs. It's also hard to get organized. We lead busy lives, and sometimes it's difficult to understand what it is we have, what questions we should be asking, how to even find an attorney, who to go to. So there's a lot of roadblocks in the way, and I want to help try to resolve some of those misconceptions and encourage you to complete the process and give you a path and a map to get there. So we'll start with to dissuade this misconception that estate planning is just for rich people. Let's think about what happens if you don't have an estate plan. And that may be many of you right now. Maybe you've started the process and you just haven't gone all the way through. Or maybe you haven't even really thought about it and saw the email come across and thought, oh, that's a good idea. Maybe I should learn something about this. So we'll talk first about what is the alternative if you don't have an estate plan. Well, each state has its own set of default rules. These are called intestacy laws. Intestacy is simply a word that means that you died without a will. So it's the law that's in place if you didn't leave anything indicating what you wanted. And these laws are intended to be similar to what most people would want. However, it's not always the case. And it turns out that most people may not want what these default rules say. They can vary, not hugely, but they do vary from state to state. So one example is if you die with a spouse, some states allow everything to go to the spouse. Some states have a portion to the spouse and a portion to your biological children. If you have a blended family, say you're in a second marriage, you have children from your first marriage, your spouse has children of their own. Sometimes there's a division along a certain percentage to your own biological children. And if you have no spouse, it's often, do you have any surviving children? It would go down to them. And it can also, if you don't have any children and no spouse, it can go up to your parents and then over to your siblings and nieces and nephews. And that's the general flow. But again, every state is different. And so understanding what your state's default rules with the intestacy laws are in your state is important. And it may not be what you want. And even if it is what you want, it's often a pain if you haven't named someone in a document for who is in charge to help administer your estate when you pass. So if you die without a will, there could be somebody who could be appointed as an administrator of your estate. That person often has to post a bond, so they have to put money up. They have to, be eligible to do that. And there can be a priority order for who can be in place. In some states, creditors can become appointed as an administrator of your estate. So the alternative is not nothing, but it's usually not preferred. So it's always best to have a plan and to be able to be in charge of who you name and what you want. One other thing to think about is how your assets are titled. Some people might say, well, why should I do this? Everything I own is joint with my spouse. Everything should go to them when I pass. And that may be true. Either stuff is joint with your spouse or there's a beneficiary designation on your retirement or your life insurance. You may have forgotten about a life insurance policy you had or your parents got for you when you were little and you didn't know about it and it's in your name. Or there might be assets out there that you didn't realize didn't have a beneficiary designation on them anymore. If those don't have a beneficiary or if there's something in your name, then you have to do what's called probate your estate. And if you don't have a will in place or the person in charge that you want in charge, then that can be a real problem. So I'll start, our first vocabulary lesson for the evening will be what a probate asset is versus a non-probate asset. And we'll get into this more when we talk about going through what assets you have to list for your attorney or accountant or whoever is helping you on your team. A probate asset is an asset in your individual name. It doesn't have a beneficiary designation. It doesn't have a joint owner. It is just yours. And at your death, that asset has to be governed either by a will or it has to go through the probate process and pass through intestacy, whatever those default rules are under your state. Now, in order to administer those assets, an executor or administrator has to be appointed. So you have to think through as part of this process how your assets are titled. Whose name is on the account? Is there a joint owner? Is there a beneficiary designation? That is what your will control. Your will control all of your probate assets, and we'll get into this more later as well. Your non-probate assets are assets that have a beneficiary designation. They're owned jointly. They might be assets that are transferred to a trust during your life. They're assets that pass by virtue of the trust agreement or the joint ownership or the beneficiary. They pass automatically to that person who's named. They don't have to go through the probate process. They don't have to have the local probate court overseeing the process, and they just pass automatically to the spouse. Often this can be preferred, especially if you live in a state like I do in New York, where depending on where you live in New York, the probate process can be expensive and very time consuming. It depends on where you are in the state, but it certainly can be the case. When I was practicing in West Virginia, it was less of an issue to avoid probate because it was not often as expensive or as time consuming of an ordeal. But places like California, Florida, New York, a lot of the places along the East Coast that are more populated, there can be very good reasons to avoid probate. And we'll get into that in a little bit more detail. So other reasons that you should consider doing this. Being prepared just makes it easier for your loved ones. This is your way of showing them that you're organized. This is what you want. These are your wishes. You took the time, went to an attorney. They put it into legal language to make it official. And, one other roadblock that comes up is often people are intimidated by the cost of doing this and meeting with an attorney. And that's understandable. It's not cheap, but it's money well spent, especially if you're working with somebody who is really helping you think through all of the what ifs. The money spent up front really reduces cost in the long run. Some of the most drawn out and expensive administrations I have dealt with was when people didn't plan or they planned poorly, or their assets and the titling didn't match what was in their documents. And so their documents didn't actually carry into effect what they wanted. So the cost on the front end to get organized and get a plan and update it is really, really goes a long way in the long run. It ensures your wishes are carried out with respect to who you want to benefit. Those default rules aren't necessarily running the day. And also, if you have the privilege of having amassed a significant amount of wealth, there can also be significant tax savings with this. I won't get into a lot of detail on the specific tax savings. That's a whole separate presentation. And given the significant increase in the federal estate tax exemption, that's going to be starting in 2026, and it's kind of been in the works for the past 10 or so years. It doesn't affect as many people, but it is certainly something that should be in the back of your mind, especially if you live in a state that has its own state estate tax or inheritance tax. I don't have a list of all those, but New York, Pennsylvania, Massachusetts, Connecticut, Minnesota, I think Illinois at one point had it. Pennsylvania has an inheritance tax, not an estate tax, but there's a number of states that have their own separate tax. And so planning for that and making sure that you talk to someone who's knowledgeable can really help you save money and make sure that more goes to your beneficiaries or to charity, whoever you're deciding you want to benefit down the line. Okay, so what is involved? What are the documents involved in a typical estate plan? And again, they can be called different things from state to state, but we'll start first with some of the lifetime planning documents. First is a durable power of attorney. This is your financial power of attorney. It indicates, names somebody who is in control of your finances while you are living. Typically, you appoint somebody who has that control concurrently with you, not just if you become incapacitated. Most of the time, the person will not act unless they need to. But the whole point is to give someone the keys to your house ahead of time so they have it when you need it, rather than have to prove to a financial institution that you no longer have incapacity. Powers of attorney can be some of the most difficult sometimes for financial institutions to accept. They have a lot of review of these. There's a lot of fraud with them. So it's a powerful document. You want to make sure you pick someone that you trust as your agent. But it's also important that you don't have these added steps of requiring incapacity for it to be effective. There are powers of attorney that can be drafted so that they're only effective upon incapacity. Those are called springing powers of attorney. And that is an option, but I typically recommend to people that if you don't trust the person you're going to name while you have the capacity to know if they're doing something shady, then maybe you shouldn't name them at all. So that's one thing to consider, is someone who could be responsible and help manage your finances. And these are broad. It gives a wide variety of powers. Some states have statutory forms. If you work with an attorney, they may add to those powers, give power to do estate planning and beneficiary designations, making gifts in the event you're incapacitated. The alternative to that, if you don't have that and you become incapacitated, the alternative is a court-ordered guardianship, which can be a long and expensive process, and depending on your family, can also be contentious. So, naming the people and successor agents who you want to be in charge of your finances to help can be extremely beneficial. There's also the healthcare proxy or healthcare power of attorney, and often that goes hand in hand with an advance directive or a living will. Again, these are called different things in different states, so I'm just trying to use the terminology that may sound familiar to you. This names someone to act on your behalf with regard to medical affairs. Now, this document only comes into place when you can no longer make your own medical decisions. And the living will speaks to your end of life wishes. A trust can be a very important lifetime planning technique. And again, this is not something that's just for rich people. Well, if you have a lot of money and you started your own business, you've liquidated it, even if you have a lot of money, there's certainly tax planning and stuff that can be involved with the trust, but it can also be helpful for long-term care to try to protect assets from a Medicaid lien, or it can just be helpful as a probate avoidance tool. So if you put assets into a trust during life, they are no longer probate assets. So they pass automatically according to the trust terms. So it avoids, if you are able to get everything into a trust, it can avoid the need for a probate process generally. So there's revocable versus irrevocable trusts. And an irrevocable trust is a trust that cannot be amended. A revocable trust is the opposite. It can be amended or revoked. Irrevocable trusts can be used for asset protection, for making gifts, so there can be good tax reasons to do so. There's also an inter vivos versus testamentary trust. So the inter vivos trust is what we're talking about, the trust that is during life. This is usually a lifetime planning. It can be used, say you transfer assets into a trust to avoid probate. You can still control what goes in, what goes out of the trust. It's there to benefit you. The main benefit is that it avoids probate. It provides a little bit of privacy. You don't have all the filing requirements that are generally involved in the probate process in terms of what's the size of your estate, what are your assets, etc. A testamentary trust is a trust that comes into place usually under a will, which moves us along to the post-death planning. There's two main documents that are generally in play after you die. That once you're deceased, the power of attorney and the healthcare proxy are no longer effective. Your will is the one who names someone who's in charge, usually the executor or personal representative in some states. If you have minor children, it can name a guardian. This is very important. If you have minor kids, you want to make sure your wishes are known as to who is taking charge of them. It also provides them with the necessary powers. Again, the will disposes of your probate assets. So these are, again, the assets just in your individual name. If everything's joint with your spouse, you may not have a probate at the first death, but at the second death, all those assets inherited from the first spouse will be probate assets, and your will dispose of those. It can also establish continuing trusts under the will. Those are the testamentary trusts. And the reason to have a trust for beneficiaries are manyfold. The trust can either be through, the will can pour all the assets into a trust that you created during life. That's sometimes called a pour over will, or it can be established under your will. There are a lot of different reasons to have trusts. Again, not just for rich people. Do you have minor children? You never want to leave assets outright to a minor child. That adds a lot of complication. A guardian has to be appointed for that child, even sometimes if it's the natural parent. Sometimes a guardian they have to get appointed as guardian to receive life insurance or retirement beneficiary designation. So creating a trust to hold those funds until the child is old enough can be really important. You may have a beneficiary with special needs. You don't want to have that beneficiary kicked off of government benefits. Sometimes those benefits can be means tested, and so if they inherit something, they may not be able to be eligible for the programs that they were receiving. So definitely things to bring up with your advisor as you go through this. You might also consider your beneficiary's level of responsibility. Can my kid handle money? Do you want to give money to your child, or will they blow it? Do you want provisions in place, guardrails there, so that they don't go and spend it all in one place? It can also provide asset protection for a beneficiary along the same lines. One thing a lot of people don't think about is asset protection can also be protection from a divorce. So if you have an adult child who's married, say you like the spouse, but you're a little unsure if it's going to last, or you have a young child who isn't married yet and you just aren't sure who they're going to meet and what's going to come into their lives. So it can provide asset protection for those beneficiaries to keep those assets in trust. And it can also, again, provide tax benefits if you are so lucky enough to be able to plan for that. So when should you go about this? I'm obviously biased, but anytime. Like I said, I mean, really there's needs, even if you're single, you have no kids, you're not married, you're young. If you want your assets to go to a certain person, it's a good idea to have a plan. You're an adult, you haven't named anyone to make medical decisions if something happens or financial decisions. So it's important to have at any point in your life. I would, highly recommend doing it and then revisiting it every couple of years, saying, hey, is this still what I need? Maybe it is. You leave it for another couple of years. Your priorities may change over time. If you have children, your children get older, you start seeing the human that they become, and how they handle things. And so you may have differences in how you want to deal with stuff. So revisiting every couple of years just for yourself, and then maybe, big life changes, right? You have a child, you have a grandchild, somebody passes. We often get people calling who have just had to administer a parent's estate or something else, and they realize that it can be a very difficult process, and they want to get stuff in order and get organized for their own children to make sure that their affairs are in order. Okay, so we'll get into the how. How do we go about doing this? The first thing I recommend is you got to pick your team. Find an attorney or an accountant or financial advisor. Maybe you already have one of these and they can help recommend others. Talk to a friend, see if there's anyone else who has done planning or has someone that they would recommend. I know there are a lot of resources out there online, and they can be valuable, especially on the educational piece, at least to get some information about the basics and the terminology and maybe what it is you might need. I don't recommend some of the LegalZoom type sources, and I'll tell you why. They're cheap, which is great, and they have They purport to be applicable to all states, no matter where you are, but they don't tailor the solution that they need for your particular situation. So a lot of time, I've had many friends who have gone through and done it through LegalZoom, and they don't necessarily take into account, what your particular assets are, how they're titled. A lot of, we're at my stage in kind of your early to mid professional career, you're developing your retirement plans. You may want trusts to have your retirement plans pay into a trust. But if you, tell the program or whatever is spitting out a will that you just need something simple, it may not get you what you actually need. So I think it is very helpful to talk to at least an advisor. And again, I realize I'm biased from this, but I have seen a lot of, on the other end, flip side, I have seen a lot of messes. So I do think it's time and money well spent. The next thing, and you don't have to do these in any particular order, but, and that, while you're getting recommendations for an attorney, get organized. Go through, and we'll talk in the next couple slides before we get into questions. We'll go through, the main 3 questions you want to ask yourself and get organized on is, what do you have? What do you own? Who do you want to benefit? And who do you want to be in charge? It comes down to those 3 questions. I will say that the most difficult, and a lot of the time that I spend with clients that could be more efficient, is trying to help them figure out what they own. And it might sound silly, but most people don't actually know what exactly it is they own. They may not know how it's titled. Oops, skipped ahead there. So you may generally know, say, oh, I have some accounts at Chase, or I have, a Fidelity 401k, or I have an investment account at Schwab. I have a house, but you may not be intimately familiar with it. How exactly is your house titled? Who is on your bank account? Is it joint with a spouse? Is it joint with a parent, with a sibling, with a child? Are your investment accounts, is there a beneficiary named on them? Sometimes financial advisors will encourage people to name transfer on death beneficiaries to avoid probate, which is a valid consideration. But if, for example, you have an estate plan with lots of tax planning and you need assets to actually flow through the trust that you created, a transfer on death beneficiary can be problematic. So it's important to coordinate your team. If you have multiple advisors, get everyone in the same room. Sometimes your financial advisor can be the one to really help you, chart out what it is you have. I often have a very simple spreadsheet, a blank spreadsheet that I share with clients and just say, hey, fill this in to the best of your ability, and then we'll have a conversation. And I can usually get the details from there. But coming prepared with what it is you have, what bank is it at? You don't need exact account numbers at this stage. And I know investments vary and fluctuate significantly from day to day, but knowing what you have, what the approximate value is, and how it's titled. Is it joint? Does it have a beneficiary on it? Especially with life insurance or retirement assets that you might have, through work, you may have named a beneficiary when you first started your job, and now you're 20 years in and you can't remember who was named, or you may not have updated it. So all of those things, it's a good opportunity to go back and double check all these things. It's also very helpful to have this list of assets in one place for the people in charge who have to marshal them upon your death and try to figure out what it is you have. Also important to think through your real estate. And this is another reason, could be another reason potentially to have to create a trust to avoid probate. Real estate is something that's not uncommon. Some people may have a vacation house or a beach house, or maybe their parents had a house in a different state where they lived and they've passed and left it to your siblings, you and your siblings. So you have real estate in multiple states. That can be a very good reason to have a revocable trust to avoid probate in both of those states. Again, you don't have to have a large amount of money or assets to have an issue. There's no need to have the time and expense to have probate twice. So getting all of this information in one place on a spreadsheet will help you understand what it is you have, as well as kind of getting it organized, and your attorney can help think, okay, they look at your total net worth, and that includes, mortgages or other kinds of debt. And they'll say, hey, you may have a tax problem. Here's how we figure that out. Or they say, look, you don't have a tax issue. So, where do you want stuff to go? Are you, are your kids able to handle the money that they get? Retirement assets have some income tax consequences to inheriting those, so they can talk that through with you as well. So this is a great opportunity to get organized and be prepared for that first initial meeting. Most attorneys will have you fill out a questionnaire of some kind that has this information on it. And some of it may be inapplicable. You may not have your own business. And sometimes that estate planning questionnaire intimidates people. And I always tell clients, don't be intimidated by this. Put it in, you can handwrite it on a list, on a grocery list, post it or something. I don't care how you get it down, but I just need to have a sense of what it is and what you have. And it always helps to stay organized, and it makes the most out of your attorney's time as well. Okay, and then you have the question of who do you want to benefit? If you have a spouse, it may be that spouse. It may not be. Maybe you're in a second marriage. Maybe each of you have enough assets and you each want to benefit your own kids. You want to protect your assets for your own kids. Maybe you've signed a premarital agreement of some kind, and you want to abide by that. So it's not always a default that everything's going to go to your spouse. Maybe if you're older, maybe you really want to benefit kids and grandkids first. You want to make sure there's enough for the spouse, but you might want to make specific gifts to kids, grandkids, charities, other friends or family members. So think through, do you want everything to provide for your spouse? And then, at your spouse's death, do you want assets to go down to your desired beneficiaries? So everyone's going to be different. I've not met a family or an estate plan that's exactly the same as someone else's. Everyone has different assets. They have different family, different friends, different situations, different wishes. So it's all really dependent on the person. It's a great opportunity. Part of why I love this job is you get to know people and kind of what they, how they operate and what they want to do with all of their hard-earned money. So, and as you're thinking about benefiting, if you have children or grandchildren, as you're thinking about benefiting them, keep in mind, your attorney may ask, how is your child with money? Or do you have concerns? Do you have concerns about a spouse? Do you have any addiction concerns? That can be a pretty serious one, where you want to have the funds there to help them get treatment, but you may not want to give them full access to them, as that can be dangerous. So there's a lot of considerations, and it's important that your attorney knows some of these issues in your family. So don't feel, there's an attorney-client privilege. They are to keep everything confidential. So feel like that you can open up about your family and explain why it is you want to do what you want to do. Sometimes it takes a couple of meetings to get information out of clients, and it can change the plan. So think through who it is you want to benefit. You could be, if you don't have children or you don't have descendants, you could want to benefit siblings or nieces and nephews, or you could want to benefit charity. There's a lot of really good ways, both during life and at death, to create vehicles to benefit the charities of your choice. And if you have a taxable estate, that's a great way to reduce estate tax or gift taxes through benefiting charity. The other thing I would encourage you to think about, again, this goes back to one of the main roadblocks, which is thinking about, no one likes to think about death. Your attorney may ask, but if, say, everyone dies in a common accident, who would you then want to benefit? All my clients groan at that. Wait, really? And we always think about, it's very rare, and we don't want people kind of staying up at night thinking about it, but it is helpful to have a contingent list. So you may be asked that, and sometimes it can hang people up and prevent them from getting their planning done. And it shouldn't do that, but think through, if at that point the people you want to benefit, are you okay with it passing under the state's intestacy laws? Or do you have a charity of choice that you want it to go to? Or do you have friends who may not otherwise receive the funds? So keep those in mind, keep a list. Your attorney will want to know who you want to benefit. And then lastly, this is also another decision that can be very crippling for some people, because it's difficult to think about who to pick, about who is going to be in charge. And there's a few different roles that you're going to want to think through, and some of them have similar skills. So your healthcare representative is really the one that's a unique skill set. This is someone who, again, this is for the healthcare power of attorney or the healthcare proxy, and enforcing your end of life wishes. This is someone who can deal with a hospital in that event. They can go to a doctor, you feel confident that they would understand what's needed for your care and make the responsible decisions and do what you would want. It doesn't necessarily have to be someone who's good with finances. They can be very different people from some of these other positions. So someone who's good under pressure, you may have someone in your family who's in the medical field and can understand, doctors and nurses. So the healthcare representative is one of the more unique roles in terms of a lot of times someone who you might select as a power of attorney or as an executor trustee, they may have similar skill sets, good with money, financial responsibility, able to seek help, know when to ask for advice and not just plow ahead. So able to seek help from accountants, from attorneys, um, and just generally be able to say, no to a difficult beneficiary, for example, if you have someone that you want to benefit, but might be difficult. So your healthcare representative is going to be kind of unique, and you'll want to think through who you would want to be in that position. And then your power of attorney, again, this is someone that while you're living could potentially act on your behalf. If you're married, it's often a spouse, or an adult child, maybe it's a parent. You always want to name successors and have at least two in mind if you can, in case something happens. I just had a call with a client this week where she's the power of attorney for her father, and she was just diagnosed with breast cancer. And she does not get along with her brother, who does not handle finances well. And there's nobody named after her in her dad's power of attorney. Her dad is almost 100, I think. And but he did not name a successor agent. So if something were to happen to her, which she was concerned about, there would have to be a guardianship proceeding. So he did the right thing. He went and got a power of attorney, but he didn't name a successor representative if something happened. And again, none of us want to think through these things, but it is important just to have those backups. One thing that I should put on here too, I should have had on here, is guardian for your minor children. This is a really tough one, especially for those who have young children. It's a really hard one to think through. So, it could be family, it could be a friend. It's the person you trust to take care of your child, and also handle finances. There could be two different ones, depending on the state that you live in. There could be somebody to handle the power of the guardian of the person or guardian of the property. So you want to talk to an attorney about those different roles if you can bifurcate them. But that's also a very important one to think through and to have successors. And then you have your executor and your trustee. These can be the same person. They don't have to be. Again, these are fiduciary roles. So they have a duty to help to administer the assets for the benefit of your beneficiaries. They cannot benefit themselves. They may be able to receive compensation. Most states will allow a reasonable compensation. Sometimes it's set out in statute. Sometimes it's just whatever's reasonable. And the executor is a shorter term position. So this is the executor under your will, which administers your probate assets. At some point, your estate will be closed. So typically estates can last anywhere, it's usually about a year. But they can, if you have a tax return to file, estate tax return, they can be open several years. They could be open decades if there's litigation or conflict. So executor is typically a shorter term position. A trustee is usually longer term. If you have a trust for children that isn't, it's in trust for their lives, it could be somebody who could be serving for a very long time. You definitely want to have backups and successors, and you want to ensure there's a mechanism in the documents for naming successors so you don't have to go to court to appoint that person. So those are thinking through who is going to be in charge. Who do you trust to administer your assets for your beneficiaries? And you want to think through too, how do they get along with your beneficiaries? How do they know your family? These could be individuals, they could be family members, they could be corporations. If you have a relationship with a bank that has a trust department and you feel comfortable and you really want an independent trustee, a corporate trustee could be a good option. Some people are concerned about the cost of that, which usually they would probably charge a fee, whereas a family member may not. But they also are generally relatively conservative, and you may need an independent person coming in and saying no to a beneficiary. That may be why you're having a trust in the first place. So these are all considerations to think through and talk through carefully with your advisor. But again, all of this is helpful to come prepared to that first meeting. And this is stuff you can think about without engaging legal counsel. You can think through all these things and talk with your spouse or your loved ones about what you want to do. And that will help make the most and reduce the cost of your plan when you do get started. So with that, we wanted to leave a significant amount of time for questions because we are assuming that many of you may have questions. You're welcome to ask specific questions. Again, I can't give specific legal advice, but it's possible that I've heard a scenario or something similar and can help give some general advice.
Thank you so much, Rebecca. You have obviously, when you have Davidson folks and you tell them you're supposed to end at a certain time, they do it. Wow. I've never seen anybody do so well on your timing. Thank you so much. And you obviously got the gears turning for people because there are a lot of questions in here that I'm going to ask. A reminder to everyone, ask more questions, throw them in the Q&A box. We have about 20 minutes to ask specific questions as much as we can, as Rebecca gave a little bit of a caveat there. Thank you so much for the presentation. So the first question that I have here says, how would assets that can't be titled be handled? Would a will designation for that asset allow one to avoid probate?
So that's a great question. A lot of times, I think those are mostly probably geared towards tangible items. So jewelry, furniture, furnishings, artwork. A car has a title. But yes, that's a great point. Wills generally do control your tangible assets. Most wills will have a article in there that says, I want all my tangible items to go to my spouse and then my children. And this is anything that you can pick up and touch. That's not it's not a dollar bill, it's not a coin that actually has monetary value, but it can be photo albums, sentimental items, all of those things, all the stuff that we have in our house. And it varies by state how you can designate that. So you can assign those assets to a revocable trust. So some states allow, you can make an assignment and say, I assign, which just means to transfer. It's just the legal word for transfer. But I would like to transfer all these assets to my trust during life. And that's essentially evidence that, hey, I was trying to make this a non-probate asset so it wouldn't have to go through my will and be subject to surrogate's court. Or sorry, in New York, it's called surrogate's court, which is an odd term for it, but probate court in most places. So tangible items can be assigned to a revocable trust to try to avoid probate. And again, a car has a title, so that would actually have to have a name change. Some artwork may have a title to it. I haven't dealt a lot with artwork that does have a title, but there may be assets where you can actually do that kind of transfer paperwork and say, I want to put this in my trust during life just to show that I'm intending to do this. If not, it's also something, even if you have a pour over will, so a will that says, hey, I want everything to go into my trust. Sometimes the will just dispose of the tangible items and then leave everything else to the trust. And that's often, it's another good thing to think about for your executor is making sure that they can get organized and, do all the logistical planning to separate that out and ship things to people or do an estate sale, all of those kinds of logistical things. But yeah, those are certainly disposed in accordance with your will. And that can be something, you don't generally want to divide up, if you split your assets, your tangible property equally among your kids, you're not cutting the couch into three, right? Usually the language will say as substantially equal shares. Some states allow an actual handwritten, or it doesn't have to be handwritten, I'm sorry, typed. They'll allow a typed memo that you can update over the years, and that's still legally enforceable. New York does not allow that. So it depends on the state and whether it has this concept called incorporation by reference, which is where it incorporates a document into the will to make it a part of that will, and you can change that document anytime and it's still legally enforceable. New York does not have that capability. So I usually call it the guilt factor. You can have, you basically say in the will, I will leave my tangible items to my children in accordance with any memorandum I may leave. And it's not legally binding, but it has that guilt factor. If you trust your executors to do the right thing, they will do that. If you have really, really important specific items you want to list in your will, you can. I generally don't like listing out having a long list of tangible items because you might sell your jewelry, you might lose something, you might give it away during life, and then you have to redo your will every time. So that the memorandum concept is a very good one. And you should ask your advisor whether you're allowed to have something that can still be legally enforceable or whether it's more of a guidance to your executor.
Oh, thank you. That's detailed.
Sorry, that was a lot.
No, that's good. Here's another question we have. What are some of the perceived barriers to creating a trust? Is there a threshold of income that makes creating a trust ideal?
So no, I think that creating a trust is really what is your goal? Is your goal to avoid probate? Because if you have a goal of just avoiding probate, then no matter even if you have not very many assets, say you have your house, a couple bank accounts, and maybe you have I'm trying to think what else. Like a small investment account or something. You can retitle those in the name of your trust and not have to go through the probate process and then just have everything go outright to who you want it. It doesn't mean you have to have it continuing. So the trust can serve its purpose both during your life for incapacity planning. It can be helpful. It can serve kind of like a power of attorney if you get assets in the name of the trust. The succession of people who can come in and help uh, pay bills or provide for your care is sometimes a little bit easier than a power of attorney. So you don't have to have a certain amount of money to have a trust because it really depends on what the purpose is. If you do want to have tax planning and your state does not have an estate tax, typically, the federal estate tax exemption is 15 million a person, and you can double up if you're married. So we're talking, pretty big money for the real tax planning benefits of having a trust, but there are really good reasons to have it that are not solely for that. And probate avoidance is one. Privacy. When I was in West Virginia, a lot of times there's a lot of people with mineral rights or oil and gas interests that have a substantial amount of wealth, but they may live in a rural county and they don't want people knowing that they have a lot of money. They don't want their neighbors knowing that they have this or what it's worth. So privacy was a big concern for some people. And some people just were private people. They just didn't want it public. When you have a probate estate and things that are in the probate court, you often have to list what the assets are to some extent. And some people are just very private by nature. So even if it wasn't about wealth or people not knowing what you have, they just may want more privacy. So there's never, you have beneficiaries who may have special needs or may have issues. You don't have to have a ton of money to put stuff in trust. If you're dealing with a corporate trustee, they will often have limits. So if you're wanting to name like a bank or a corporate trustee, they often will have, they have to have X amount of money for them to administer. It depends on the institution. So if you're going that route and you're thinking that's something to ask a corporate trustee. But yeah, there's a variety of reasons to have a trust that are not solely just for managing or earning wealth.
That's great. There's several questions about trust in here.
Sure.
This one says it's an elementary question, but it's one I actually ask as well. How important is it to have all cars in both names, mine and your spouse or partner? How much are things like this not worth worrying about?
So that's a good question. It really depends on where you live. I mean, if the probate process is not particularly difficult, it may not be a huge deal. I mean, usually we're more focused on some of the larger assets like your house or making sure your beneficiaries are updated on retirement assets, life insurance, that kind of thing. I mean, having stuff joint with a spouse or with somebody else can help avoid probate. So it can, if that's the only thing that's going through probate and then you have to open a probate just for that, it can kind of be a pain. But it's not, I would say that's it's not going to make or break your estate plan, but it's something to consider. I mean, what are your goals? Again, if probate avoidance is a goal, then yes, you should have it joint with somebody. But consider who your joint owner is going to be. Do if it's not your spouse, are you concerned about any liability that the joint owner might bring to an asset. So, you don't want to be driven just by avoiding probate. You want to consider some of these other things as well. But
Okay.
oftentimes, most states will have a small estate administration procedure too, which is under a certain limit, and it varies greatly state by state. So, if you have an asset like just a car, that's all you need to administer. There may be a simplified procedure to do that with. So I wouldn't, it's a good question and something to think about and ask your attorney, does it make sense where I live to go that far in terms of making things joint to avoid probate?
Okay. Thanks. We got a lot of good questions here. This is fun. This one says, I live in North Carolina, which does not recognize common law marriage nor domestic partnerships. I'm not married to my long-term partner, but most of our assets are jointly owned or we are named beneficiaries. Neither of us has children. Is a will sufficient to provide guidance for how assets are distributed, even if we are named as beneficiaries, or is it better to establish a trust? Lots of questions around trust, I see.
Yeah, that's a good question. I think it depends on what you want to happen with those assets, both at the first death and at the second death. If everything's joint and is going to go to the person that you want those assets to go to, that's great, but you have to consider what's going to happen then. Do you want stuff in a trust for that person? Are you concerned about undue influence for that person? Are you concerned about a new relationship that person might be in if something happens to you? So, a trust might be a good idea if you really want to benefit that person, but still control the ultimate disposition of what it is you've worked to earn. I don't think it's different the fact that you're not married or not. I mean, I think it's the same consideration even for those who are, if they have everything joint with their spouse. Do you want to prevent one of my former colleagues used to call it the casserole lady, the person coming in after them. So again, we have to have a sense of humor about this, but you do an undue influence, right? Do you want to have stuff in trust to kind of benefit, make sure that they're cared for, but you don't want someone coming in after you're gone and influencing them in any way, or taking their assets. There is a lot of that, unfortunately. So again, I think it's a concern of like long-term care planning or asset protection planning. And I don't think it's unique just to the fact that you're not married. I mean, it depends also on the value. You may have tax considerations if you're not married and have a significant amount of money, because there are some benefits to being married with estate tax planning. But yeah, certainly something to talk about with your attorney.
Great. So we have another question kind of about a trust.
Okay.
This person is divorced, no kids.
Okay.
Their brother has a child. He and his wife have a trust. I know I want to leave my estate to a trust for her, the niece. She's
Mhm.
6. But do I need to set up my own trust, or can I leave my estate to the trust my brother has set up? We live in different states. Maryland for this one, Illinois for the brother.
That's a great question. Depends on the type of trust that your brother set up. If it's a standalone trust that's already irrevocable, or if it's dependent on them passing first. If it's only created at your brother's death or the death of him and his wife for the benefit of your child, then you probably want to consider having your own trust for the benefit of your niece or nephew. Because the trust that your brother set up may not be created until after they're gone. So if you're leaving something and say you die first, there may not actually be the entity may not be in existence quite yet. Even if it's in document form, it may not be in existence to actually hold assets yet. So it probably makes sense to have your own. But again, it could be sometimes people have a standalone trust for the benefit of their child. So if it's already created and is in existence and holds assets, then it could be something that you leave it to.
Okay.
And you could coordinate or ask your brother for copies, or have his attorney talk to your attorney too. That might be a good way to get more information.
I'm going to combine 2 questions. Do you recommend any resources to better understand trusts? And then how do you find the rules for your specific state? So like, how would you find the rules and what resources are out there? Obviously, we have lots of questions about trusts here.
Yeah. So I'm not entirely sure what types of rules the question is asking. Like,
Like the rule you're talking about, well, Illinois does it differently from New York, and New York does it differently from North
You mean
Carolina.
like yeah, I really talk to an attorney is really the best. I mean, there may be, you can try to do some general Google searches to get a sense, but sometimes it's hard if you're coming in fresh to this to understand what the results of that are and to kind of filter through the answers to either AI or Google searching. So I would highly recommend I'm trying to think if there's just basic. There are a lot of like a lot of times financial companies, like Fidelities of the world or Schwab's, they'll have kind of basic blogs or law firms will have blogs about this kind of stuff. So if you can search and you might find good information there just about general activities, you could look for a firm in your state that may have information there. But really talking to an attorney is probably the best way to figure out how it works for your situation in your particular area. It can vary by county too, within a state in terms of how difficult the probate process is.
Fun times.
Yeah.
So we have several questions left. I'm going to try to do kind of a lightning round here.
Okay.
We'll
Yeah.
see what we
I'll
can
try
get
to be
through.
quick.
I won't
Sorry.
make the lawyer try to talk too quickly. Are there states where the actual dollar value of the probated assets must be made public knowledge?
Yes. Yep.
Okay,
West
there are.
Virginia was one of those. You had to file an inventory. A lot of states have that.
Okay. And what is the difference between living will and inter vivos trust? Is one better than the other?
So that's a great question. It's a confusing name. Living will is a healthcare document. Your living will sets out your end of life wishes. So it's the pull the plug or don't pull the plug, just to be really crass about it. And then an inter vivos trust is just a trust that's made during your life. So an inter vivos trust could be revocable or irrevocable. Um, it can be just a probate avoidance or privacy tool. It could be a gift or tax planning tool. But yeah, a living will is a little bit of a misnomer. It's really generally part of your healthcare proxy or your healthcare power of attorney.
That's helpful. And this one's really interesting. I'd like to know what you say to your clients about intangible items such as social media profiles,
Hmm.
emails, and online accounts without monies.
Yeah, that's a great question.
Mhm.
So a lot of states have a Digital Asset Act, and you can name they typically there's a Uniform Act actually. You can go onto your Facebook or your social media and you can select somebody that you want to handle your profile after you're gone. If you don't select anybody, then typically if you have estate planning documents, there is likely a digital asset provision that will allow your executor to handle those. But if you've made a selection in Facebook or Google or anything to name someone to handle your assets after your death, then that will typically override who you've named as an executor. Kind of depends on the company, but yeah, that's a great question. If you're comfortable with having your executor do that, I would not name anyone in particular. But if you know someone that you want or there's opportunities to name successors, you can go into settings and change that.
Yeah. I'm wondering if you would be willing to, there are about five more questions. I'm wondering if we can kind of wrap up here and if you didn't ask a question, if someone didn't ask a question, they could drop off and you wouldn't mind staying on and answering these last few questions
Oh,
after.
no, absolutely. Yeah.
And
Yeah, no,
I'm
we can
going
finish it. I
rogue.
know I was a little long-winded on some of
No,
them,
you
so
were
I
so great.
apologize.
And I just want to say, obviously, this is a topic that is really resonating with people. Thank you so much for presenting this with us. And as a reminder to everybody here, we'll send a recording of this and we're going to continue recording the last five questions. So you can see it if you want to later. We want to thank you all for joining us tonight on behalf of Women Act and the Office of Gift Planning. We hope you have come away with some tangible help for you. And please remember that the Office of Gift Planning at Davidson's here to serve as a resource and to help you think about your philanthropic aspects of your estate planning. We will include not only tonight's slides, the recording, but we'll also include a helpful one page worksheet that Rebecca put together with some of those things you need to think about. We hope you all have a wonderful evening and we look forward to hosting more events for Davidson Women in the future. If you have ideas, please reach out to me and let me know what they are. And I'm going to get back to these questions.
I will also say I'm happy if you want to reach out to me. I have my information on the slides. You're welcome to reach out. I may not be able to answer the state specific, but I may have recommendations for an attorney in your state. So feel free to reach out. My information is on the slides.
And everyone else is welcome to stay on too. I was acknowledging the time. I like to stay on time too. So here's our other questions. I'm having trouble just finding my team. What's the best way to find professionals you trust and like to make up your team? Also, is it best to have a team in your local area? Those are good questions.
That's a great question. I find a lot of times if you can find one piece of your team, they can point you to others. If you have anybody in your family or friends or religious organization or social organization who have had this done, I would ask around. A lot of times word of mouth can be the best way. There are, you can search online, it can be a little overwhelming. There's an organization called ACTEC, American Council of Trust and Estates, or American Council of Trust and Estates Council? I don't know, but it's in a great organization. You have to apply to be a member. It's a really well regarded for professionals and also academics. And they sometimes, I think they may have a directory. I don't know if it's open to the general public, but they have some good resources there. You might be able to find somebody there, especially if you need tax knowledge or any kind of like specific help. If there's a law school in your area, someone in the faculty may know. There may be adjunct faculty who work there who might be able to give advice. But yeah, it's hard to find and put your team together. But keep asking around. Getting referrals is really the best way to do it. And once you have one person that you trust, an accountant or financial advisor or someone at a bank, they can sometimes point you in the right direction.
That's really helpful. Can you please talk about naming beneficiaries on financial accounts, children and spouses? Are there red flags for this?
Yes, I'm glad you asked. This is one situation we run into a lot actually with bank tellers and other financial advisors sometimes giving inadvertent legal advice with this. So life insurance and retirement, very important to have beneficiaries on. Those are kind of already givens that you need to have a beneficiary on those. Non-retirement investment accounts or just general checking savings accounts have what are called pay on death, POD, or transfer on death beneficiaries. And they can be really helpful, especially in avoiding probate. You can also do a TOD, POD beneficiary to a trust if you want your trust to govern. The one thing I would caution you is if you're in a state where there are we run into this a lot, again, in New York, where there is a lower estate tax threshold. You want to make sure that the assets on each side of the balance sheet are balanced so that you're fully utilizing estate tax exemptions. Sometimes having a beneficiary in those accounts can avoid the assets actually flowing through your plan and using up exemption. So there may be a reason to have assets actually be probate assets, or at least within a trust that actually flows through the trust that you've created for beneficiaries. So there are good reasons not to just name beneficiaries willy-nilly, especially if you have substantial assets or are in a state that has a low estate tax exemption. So it's one of the common mistakes we see is we've created a plan for somebody based on the information they've told us, and then they didn't want to pay to ask additional follow-up questions, and they went to their financial advisor who then wasn't aware of their plan and had them name beneficiaries and everything, and then it just totally undid what they paid money to do. So it's a good reason to have kind of coordinate efforts and make sure everyone's on the same page. But yeah, there are good reasons not to do it, but it can be very useful as well, as opposed to naming a joint owner where you're sometimes concerned about putting someone joint on the account when you're living.
Oh, that's helpful. And along this same line, is it problematic to name several people as joint executors, such as 3 children?
So that's a great question. I would say talk to, again, it's state specific, county specific. Depends also if they live in the same area. Practically speaking, it can be a little bit cumbersome to have. Sometimes you may have to have 3 people sign off on everything, or at least the initial paperwork. We see 2 pretty frequently. More than 2, I generally try to discourage because it just can be impractical to have everybody sign off. Generally, there's a succession, right? So you can name, a lot of times people are like, well, I don't want my child to be offended that they weren't named first. And I usually try to say, it's a job. The executive trustee is a job. It's not, it can be an honor to serve that for somebody, but it's also not fun. It's a tough job. So, don't no, don't name people just to feel like because you feel guilty about leaving somebody out. You can also always have a succession. If somebody doesn't want to serve, they could have the next in line. So I would encourage not naming more than two, just for practical reasons.
That makes sense. And what if you reside in two states, winter in North Carolina, primary residence, and summer in New York, vacation home? Do you need two attorneys lined up?
So I would generally say wherever you view your permanent home. So probably in that case, North Carolina would be where your tax residence is. That's probably where you're going to be what's considered domiciled for estate purposes. And you definitely don't, if you have a house in North Carolina and live there, you don't want to be domiciled in New York because you have a state estate tax. So I would recommend, we always try to recommend people get out of New York if they're concerned about taxes. So if it's just a vacation, but if you're up for a significant amount of time, you could have a healthcare power of attorney or a power of attorney up here in New York. But New York should recognize, the states should recognize each other's documents if they were validly executed somewhere. If you spend like roughly half the year somewhere and half the year somewhere else, it may be good to have two sets of those kind of lifetime documents, but you want to make sure they don't revoke the other. So you just want to coordinate if you do seek advice from somebody in a different state, you just want to coordinate with your home state. But I would focus on the North Carolina piece in that sense. It sounds like that's your primary residence, and those documents should work even if you're up in New York and something happens.
Great. And I think you mentioned this question, but any positives in going through probate, or is it pretty much avoid probate at all cost?
Yeah. So it's not, and it's really not avoid probate at all costs. It really depends on where you live. In West Virginia, we did not it really depended on the person as to whether it just wasn't very expensive. A lot of people could do it on their own. I mean, with some advice from counsel, but it wasn't that time you could walk in and get appointed as executor that day, depending on the county that you lived in. So it's not an avoid at all costs kind of thing. It really depends on where you live. It can just make things a little bit easier to have stuff in one pot. It's kind of like doing the work if you want to avoid probate, put stuff in a trust for probate avoidance, you're doing the work ahead of time to kind of get it in one place and get everything organized. So you're putting the cost and the effort up front versus leaving it for the people who are in charge after you're gone. But again, if you live in New York City or if you live in California or Florida, can be pretty time consuming. It is avoid probate at all costs just because it can take a long time. So again, very dependent on where you live.
That's great. Someone has asked, you talked a little bit about some of the websites like LegalZoom. This one says there's a website called www.trustandwill.com that can be used to set up one or both. Are you familiar with it? If so, do you think, is it a better alternative, I guess, or is it an okay alternative to having an attorney?
So I actually had somebody come to me and they had a trust and will account and they had all of their assets in there. I thought it was helpful in getting all of that stuff organized. I actually got a lot of emails from them because I had to sign up as an advisor, have an advisor account. So I'll be honest, I haven't worked with them a lot. I think it can, but they do seem to have a platform where you can kind of get your assets in and get organized, but it didn't give me all the information I needed in terms of how stuff was titled and how much did you have in retire, like how much was your retirement account? Sometimes that's a big question because retirement assets are a little bit restrictive in inheriting them. So there were specific questions that it didn't give me all the information I wanted in the format that I needed to really develop the plan. The person ended up just not moving forward. And I'm not sure if they went with a plan developed by Will and Trust, but I do know they seem to have a decent platform, but it may be good to do in conjunction with someone. Or there's a lot of apps and other stuff that help you get your finances in order and get stuff in one place. And those types of things would be a really good tool to get organized before going to an attorney. So yeah, I'm familiar with it, but not overly familiar.
Okay. And we're getting close.
Okay.
What about a POD bank account? Is this often used without a trust?
Yeah, so that can be a tool to avoid probate. If your goal is to get it to somebody and you're okay with that person getting it outright, you don't want any restrictions on their inheritance. Yes, it can pass automatically to them outright. So yeah, we've talked a little bit about that, just passes to whoever's named on the account.
Great.
One
And
other restriction with POD beneficiaries is there aren't often contingency. Some institutions don't allow you to name contingent beneficiaries. So if the person you name passes, it goes back into your estate. So trusts can be a little bit more flexible than that, but it can accomplish a similar goal.
Great. And thank you so much. Those are all the questions we have. Reminder that the slides will be available after the presentation. We will send out a copy of the recording, and that also includes Rebecca's contact information. Thank you again to everybody. Thanks for people staying on for so long. Have a great night. It is always a great day to be a Wildcat. Thank you. Have a good night.